Hey out there, legal warriors. In restraining order cases in Washington State, there are two types of service. There is service of the original petition that grants the court jurisdiction for a restraining order against somebody. And there's also service of documents, declarations and things that are in response to the petition or in response to the petition. It can be confusing, and so in this video, I'm going to do my best to explain it all. If this area of the law is interesting to you, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now, you heard that I defend people charged with crimes, and Lance restraining orders aren't crimes. Correct, but violations of them are. But part of our practice also is either helping people fight restraining orders or helping people get restraining orders. Now, in Washington, the law that covers restraining orders, they're not really called restraining orders, they're called protection orders. You can find the entire chapter on protection orders recodified, fancy word for saying put all in one law, under RCW 7.105. So if you ever want to find the law, you can go to Google and type in RCW, Revised Code of Washington 7.105, and you'll see the entire law there. And I'm going to cover why service is so confusing. It's even confusing to people on my own team, believe it or not. And we're going to break down service into two different types of service. The first service we're going to talk about is if someone is trying to get a restraining order against someone else, a protection order, but we're going to call it a restraining order, then there's certain rules that the petitioner has to follow to get their order into court and then get notice to the respondent, the restrained person, so their order can actually be effective. So just to go back a couple steps, how does someone try to get a restraining order? Well, they fill out something called a petition saying the reasons they want a restraining order. There's domestic violence restraining orders, there's anti-harassment restraining orders, assault restraining orders, vulnerable adult restraining orders, extreme risk restraining orders. We can restrain somebody for pretty much anything in this state. But you fill out that petition, and then the court, typically the next day, will look at that petition ex parte, just with you, the petitioner, not with anybody else. The respondent's not there. If the court sees that you have grounds for an order, they'll grant a temporary order. And that temporary order will set a new hearing date that gives the respondent a chance to respond and say, hey, what you said, petitioner, isn't true. You shouldn't have an order against me, the respondent. And that's the document, a temporary order, along with the petition. That's one type of service. And so the return date to fight about this is typically 2 weeks after the temporary order is issued. And you, as the petitioner, are required to show that the respondent has been served with the petition and the temporary order, giving them due process, a chance to respond to you. You have to show that they've been served 7 days before the hearing, 5 court days. If there's a holiday in there, it would be 8 days because it's 5 court days. And that's one type of service. And that service is jurisdictional. If you do not have service on the respondent, the court does not have any power to proceed to try to decide if you should have a permanent order or not. A permanent order means an order of 1 year or more. Typically, it doesn't mean forever. It's a bad word, but that's the word in the statute. So that type of service is jurisdictional. If you don't have it, the court lacks power. And so who does that service? Do you have to do it, or does the police serve the temporary order and the petition? Well, that depends on what the temporary order is doing to the respondent. And that's where RCW 7.105.150 comes in. Now, if you're really feeling like you want to be a bookworm and you want to read this on your own, we're going to provide a link to that statute, 7.105.150. But it basically says, the court says, hey, the police have to do the service for you in certain situations. But if those situations don't apply, then you've got to have someone else do it for you. You cannot personally serve the other party someone 18 or above has to be the one to do it. Without getting too much into the weeds, those situations where the police are going to do it for you involve a situation where the court is ordering the respondent to turn in their guns, where they have to turn in their guns as part of the order. Situations where the respondent is going to have to transfer their child to you. It also protects the child, and you two have a child together. Situations where the person is already incarcerated in jail. Well, it's pretty easy to serve them, you know where you're at, but the police have to do that. And another common situation is where that this protection order that you're filing, this restraining order, is evicting the person from the shared residence with you. In those cases, the court is going to say, hey, the police have to file it. Now, you can't just rest on that, because the police may do the filing, but sometimes may serve the person, but sometimes they forget to file proof of service. So you need to stay in contact with the police or the court file to make sure that if they do serve the respondent, that proof of service ends up in the file. Because even if they're served and the court doesn't have proof of it, they still cannot proceed. Now, the law says that the police have to at least try 2 attempts to serve the respondent in person. After 2 failed attempts of going to their house or their work or wherever, then they can try to use electronic means of service. That's why when you fill out your petition, there's a law enforcement information sheet where you put down all the stuff you know about the respondent. What's their Facebook handle? What's their email? What's their Instagram? What's their whatever you might have, so the officers can try to serve them electronically if personal service fails. Commonly, they might try to text the documents. It can get pretty hairy. So I'm not going to get too far into the weeds about what happens if that doesn't work, but I will say that if service has not happened timely by the time you show up for that return hearing date, typically 2 weeks after your temporary order was issued, then the court is going to offer you a chance to extend your temporary order for another 2 weeks so another service attempt can happen. Now, I'll make another video in the future about getting into the weeds about RCW 7.105.150, about when you can do mail service, when you can do these other types of things, and it's very complicated. This is why you'd be wise to have an attorney helping you in these things. But that is one type of service. Now, what is the other type of service, the things that's so confusing to people? Well, it's the same word, but it means something else. That first service was serving the petition and temporary order. That gave the court jurisdiction to hear the argument between the parties. Now, these type of hearings are done on written words for the most part. You've written in the petition, if you're the petitioner, what happened. And if you're the respondent, you received the petition and, oh, here's all the stuff the petitioner says I did. Well, you are supposed to file a written response to the court prior to that return date. And they would call that a reply or a response, depending on which party you are. You don't really need to worry about what it's called, but what often happens is, I saw this happen at least 4 times yesterday in court, because I'm on these hearings almost every day, is that the respondent went ahead and filed their response to the court, but they never served it on the petitioner. Just like the petitioner has to provide the respondent notice of the reason why they want the order, the respondent has to provide the petitioner notice of what their defenses are. And so if you're the respondent, you need to serve the petitioner your response. So it needs to go to the court in time for them to actually read it, hopefully at least a couple days ahead of time, and some courts may have specific rules. But you also have to get it to the petitioner. If you don't get it to the petitioner, what's going to happen? You're going to go to court. The petitioner's going to say that I don't have it. The judge is going to yell at you, figuratively, hopefully, and then the case is going to get continued. So you're not going to get your day in court. You're going to have wasted your time going to court, and the order is still going to exist against you because the petitioner is required by the rules to have what you filed. So how do we serve the petitioner our response? You cannot do it yourself personally. That would violate the most protection orders, right? And also, parties aren't supposed to serve other parties. The court would say, have another person 18 years old or above serve the petitioner. Does that mean you need to go to their house? Hopefully not. I want you to take a look at the petition, and it's different on different counties, but somewhere in the petition is going to say the petitioner will have a chance to list his or her email address. And it'll say whether or not they're willing to accept service by email. Almost always there is an email address nowadays. So look at that email address and get whatever you're filing in response, get them in a nice, pretty PDF file, hopefully, right? Some type of Adobe file, and get somebody else to email that response that you're filing with the court to the petitioner. Now, this you do not need to have proof of in court. You don't need proof of service filed in court because this is not jurisdictional. I've yet to see the case where the petitioner says, I didn't get the response when they really did. Now, if you want to be safe, you could print out the email, right, or print out whatever your proof is and bring it with you, but there's no requirement that you file that type of proof of service. The other side needs the documents, but you don't need to prove it with something in court because it's not jurisdictional. If there's not an email listed, you may not be able to serve them. You could put something in the mail. Someone else could put something in the mail to them if you have the address. Someone else could go and give it to them personally, not you. You could hire a process server. But most practically, if there is no email address, it's probably going to get continued. You're probably going to go to the court. You're probably going to tell the court, I had no way to serve the petitioner. You're going to bring an extra copy with you so you can ask the court permission to hand it to the petitioner in front of the court so they are served, and then it's probably going to get continued. Now, finally, if you are the petitioner and you've been served a response, you're supposed to have an opportunity to file a reply. The same type of mistake happens here. If you file a reply to the response saying, hey, what the respondent put down is not true, this is what's really true, you file it with the court, but you also have to serve it on the respondent. The police will not do that for you. Again, I was in court yesterday and someone saying, oh, the police can serve this. No, the judge top almost exploded off their head, right? Because the police don't go around serving those documents. Those are just sort of the war of words between the parties that the court is going to look at and decide partly on who wins and who loses. So these service things matter. And, this is a bit of a longer video, but it's so confusing. One service is jurisdictional. The police usually have to do it, and there needs to be proof in the file. That's the documents that start the case from the petitioner's point of view. And then the other services need to happen. Here's my response, here's my reply. But that has nothing to do with the police, and you don't need proof of service in the court file, but you need to file your response and reply with the court so they can actually read it. Will they get to testify in court? It depends on the court. In King County, you can testify almost all day, it seems. In Snohomish County, there's a 5-minute rule. Sometimes they stick to it, sometimes they don't. In other counties, your mileage may vary. So I hope you find this useful. If so, please like and please subscribe. More people get to see this. They'll get the help they need. This is so confusing. And more importantly, if you've got a restraining order matter, protection order in Washington State, or even a criminal matter, feel free to reach out to my firm. This is what we do. We've been doing it a long time. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.